Welcome to Healthcare Ethics and Law. In today's video, we're going to look at the Mental Capacity Act 2005, and we're going to look at how it came into being, what the objectives of it are, and also look at the 5 founding principles of the Act. So the Mental Capacity Act relates to a person's ability or capacity to function and to make a particular decision at a particular time. But before we look at this in a bit more detail, what I want to do is initially take a step back and to look at the importance of this Act and why it came into being. So traditionally the law identified that in many cases those with mental disorders would have a limited capacity to make decisions themselves. So if we look at this in a medical or dental context, this could mean that treatments won't be consented to by a patient owing to this lack of capacity. So when we do this, we make decisions in their best interests, but this does deprive them of their autonomy or ability to make decisions. And we have to defend or explain this using what we call justified paternalism. And so paternalism essentially can be defined as any act which the patient hasn't consented to, and in some cases even asked for, but is provided with intention so that they don't come to any harm. And in our liberal society, autonomy is promoted, it's something that's reflected in medical ethics. So really, these paternalistic measures are seen as a last resort to protect people, and in ethics this is known as the harm principle. So the Mental Capacity Act acknowledges that we can make decisions on someone's behalf, should they lack capacity, but what it does is it sets out a series of safeguards to make sure that this is only done in really exceptional circumstances and in the best interest of the patient. So it has 5 guiding principles which we're going to look through one by one. The first principle states that a person is assumed to have capacity unless it is established that they lack capacity. So that's a really important principle and something that we should take really seriously. Effectively, this acts as a safeguard to depriving someone of their liberty who is incorrectly deemed to be lacking capacity without justification. So again, this helps us to protect individuals from unjustified paternalistic interventions, which we've discussed. The second principle states that a person is not to be treated as unable to make a decision unless all practical steps to help them do so have been taken without success. So what this means is that we need to try to help and support that individual in making a decision, and that can involve unconventional methods of communication, such as using pictures to explain the procedure to the patient. And that's really important. The third principle says that a person is not to be treated as unable to make a decision merely because they make an unwise decision. So essentially, even if we don't agree that the decision the patient is making is right for them, or even right at all, we have to allow them to make this unwise decision. And if they have capacity, then again we can't interfere with their decision-making process. A recent example of this was seen just this week at the Court of Protection, which ruled that a patient was allowed to refuse life-saving treatment as they did not want to be left with a stoma bag following the treatment. So whilst this decision would result in their death, the judge felt that ultimately, because they had capacity, we had to respect their decision. So if we think that a patient does have lack capacity, and this has been shown, then we need to apply the final 2 principles of the 5 guiding principles of the Act. So Principle 4 says that an act or decision made under this Act or on behalf of a person who lacks capacity must be done in their best interest. So in other words, if we think that someone doesn't have capacity, we need to establish what would be in their best interest as conceived by themselves. So what this means is if they had capacity, what would they deem themselves as in their best interest? There's a number of ways to look at this. For example, holding a best interest meeting, and you can discuss this with family, friends, carers. Sometimes they'll have an appointed lasting power of attorney, known as a health and welfare attorney. And if necessary, if the patient doesn't have anyone you can call upon to find out what their wishes might have been, you can always contact a mental capacity advocate. It's also important to note that you should try to involve the patient in these discussions. Even though ultimately they won't be making the decision, you should make an effort to make them feel involved and to try and get some insight into their wishes as much as possible. because that may guide you in terms of what treatment you then advocate going forwards. And then the final principle of the Mental Capacity Act states that before an act is done or the decision is made, regard must be had to whether the purpose for which it is needed can be as effectively achieved in a way that is least restrictive of the person's rights or freedoms. So what we need to do is make sure that any action or anything we do doesn't impose or overimpose on the individual's rights and freedoms. We should do as little as possible in these situations. This could be, again, an example as if a patient's temporarily lost capacity. For example, if someone comes to your clinic and they're drunk, what we should do is the least invasive procedure until they've sobered up and regained their capacity. Once they regain their capacity, they can then make that decision themselves. In summary, the Mental Capacity Act aims to place safeguards on depriving individuals of their capacity to consent for medical interventions. The Act is based on 5 principles which aim to protect patients' autonomy and to make sure that we act in patients' best interests. To find out more about the Mental Capacity Act, head over to our website, healthcareethicsandlaw.co.uk, where you can find lots more resources and summarised content on this topic.